Ever since the day that you went away, you went away. You've been spending
Question given where Atikah and Arifah are the directors and shareholders of ANA Sdn Bhd. Discuss the liabilities of ANA Sdn Bhd and the directors based on the following situation. Situation A. A loan worth 50,000 was given by Yayasan Usahawan Niaga to ANA Sdn Bhd, by which the repayment must be made within 3 years. However, until today, ANA Sdn Bhd did not make any repayment back to Yayasan. Thus, Yayasan want to sue Atikah and Arifah for the repayment of the loan. Under the Contract Act 2016, companies shall have unlimited capacity. By virtue of Section 21 stated that a company shall be capable of exercising all the functions of a body corporate and have the full capacity to carry on or undertake any business or activity, including to sue and be sued, to acquire, own, hold, develop or dispose of any property, and to do any act which it may do or to transfer into transactions. Based on the situation that had happened, the issue is whether Yayasan Usahawan Niaga had the right to sue Atikah and Arifah for not making any repayment of the loan, whether Atikah and Arifah are liable for the repayment of the loan. Under Section 21 Sub 1 of the Contract Act 2016, the unlimited capacity of a company includes the ability to sue and be sued by its own name. If any person does a wrongful act or breach any duty of a contract to the company, it is for the company itself, not the members, to take action to enforce its right against that particular person. For example, if a director of a company breached his duty to the company should take action against the director. The member cannot take any action on behalf of the company. A company may take legal action in court under its own name. Any act or transaction under the company's name will bestow legal right and interest on the company, thus enabling it to become a plaintiff. The proper plaintiff rule stated that only the party who suffers injury or loss may institute legal action in court. According to Section 192 Sub 1 of the Contract Act, provide that a member shall not be liable for an obligation of a company by reason only of being a member of the company. This is illustrated in the case of Force and Harbotter. The fact of this case is two shareholders of the company sued the director for misappropriation of the company's property. It is held that the court rejected the application on the ground that the shareholders were not the proper plaintiff as they did not have the locus standi to bring the case. This is because the injury was caused to the company, not the shareholder personally. Therefore, the company should take action as it is the proper plaintiff. By referring to the situation, Yayasan went to sue Atikah and Arifah, which is the director and the shareholders of ANA Sdn Bhd, because they did not make any payment to Yayasan even after 3 years. In Section 21 Sub 1 of Contract Act, give the company ability to sue and be sued by its own name. In this situation, Yayasan want to sue Atikah and Arifah and not the company itself. The liability is not the member's liability, so a third party cannot take any action on a member of the company. Yayasan should actually take legal action in court under the company's name because the company and its member are two separate bodies. The company must be sued under its own name and not the members of the company. Thus, Yayasan had no right to sue Atika and Arifah, and they are not liable for the repayment of the company's loan. In conclusion, a company is liable for all action undertaken in its own name, as the company and the member are two different bodies and are a separate legal entity. It was the company that should be sued and not the members.
Situation B, where Atika has issued a check to Jannah worth 5,000 on behalf of the company without stating the name of the company on the check.
The legal issue is whether the check is valid and the Atika has to be liable for the payment to Jannah. Company is an artificial legal person created by the law. Once it is incorporated, it comes into being and it is a separate legal entity from its member and officers. According to Section 2 of Company Act 2016, company incorporated under this act or under any corresponding written law. So whatever issues that arise from the company, you have to refer company's law or other written law. When there is company, there will be the effect of incorporation. One of the effects is liabilities of member are limited by virtue of Section 192 subsection 1. A member shall not be liable for an obligation accompanied by reason only of being a member of the companies. It is because the company is separated from its member. Thus, the liabilities of the company and the members will be separated. The members also cannot be liable of he or she carried out under the company's name or in company's property. However, based on Section 192, Subsection 2, Paragraph A until D, there are several liabilities for the members, but the liabilities are limited to A. In the case of a company limited by share, any unpaid amount of share that held by members. B. In the case of a company limited by guarantee, any amount that the members contributed to the company in the event of it being wound up. C. Any liability that provided in the constitution of the company. D. Any liabilities as provided for this act. So, the member is liable based on the amount that he has agreed to guarantee in the event of it being wound up. But it is based on the type of the company. Furthermore, not only the members, but the directors, officers, and also staff of the company will not be responsible for the debts. It means that the company and the members are separated. Based on case reapplication by YUA, the industrial court award was not paid and the court ordered Yi to be personally liable to the sum. The High Court quashed the order, stating that it was an error in the law. The reason it is member of the company cannot be liable for the company's liabilities. Based on situation 2B, the check that Atika signed is not valid because there is no company's name into the check, and when there is no company names, we will simplify that the debt will be paid by Atika's account. So the check is
void and Atika will not be liable for the debt to Jannah amounted Rm 5,000 because that is the company's debt, not her debt. Since the members and the company is separated, she will not be liable to the payment. So the conclusion is, to pay the debt, they must use the company's account instead of personal account. It is because it will make the transaction void because of the effect of incorporation, limited liability of the members.